Patriots, this Friday, January 9th, the Supreme Court holds conference on the AR-15 ban cases for the third time, and Justice Kavanaugh's promise to address rifle bans in a term or two is about to be tested. We're talking about Vermonte v. Cook County and Duncan v. Bonta, the rifle and magazine ban cases that have been relisted twice and survived conferences where other Second Amendment cases were denied. The question is simple but massive. Does the Second Amendment protect AR-15s and standard magazines, or can states ban the most popular rifles in America? Before we break down what this third relist means, smash that subscribe button. This Friday could determine the future of AR-15 ownership. Let's hit 1.2 million subscribers. Let's analyze what's happening at the Supreme Court. The fundamental question. Let me start with the question that should be obvious, but somehow isn't. Does the Second Amendment guarantee the right to possess AR-15 rifles and standard capacity magazines? Think about that. The AR-15 is the most popular rifle in America. There are an estimated 20 to 25 million AR-15 style rifles in civilian hands. It's used for home defense, sporting competitions, hunting, training, and constitutional militia purposes. And yet circuit courts across America are saying, nope, the AR-15s don't protect these rifles. Some courts claim AR-15s are too militaristic. Others say they can be restricted even if protected. The confusion is massive. The Supreme Court must answer this question. Americans deserve to know if their constitutional rights protect the firearms they already own. Cook County's tyrannical ban. The main case is Vermonte v. Cook County, Illinois. Cook County passed an ordinance that makes it a crime to sell, transfer, or even possess assault weapons. What does Cook County define as assault weapons? By name, over 100 specific rifles, including all AR-15 platforms, all AK-47 platforms, and dozens more popular rifles. By features, any semi-automatic rifle with pistol grip, folding stock, muzzle brake, barrel shroud, or any scary feature. This isn't common sense regulation. This is a comprehensive ban on the most popular rifles in America. The plaintiffs, individual citizens and Second Amendment Foundation, sued, arguing this ban doesn't regulate firearms, it outlaws commonly owned rifles protected by the Second Amendment. This violates Heller and Bruin. The Seventh Circuit disaster. The case went to federal district court in Chicago. While the case was pending, Illinois passed a statewide assault weapon ban, PICA, with similar language. Around the same time, the Seventh Circuit decided Bevis v. Naperville, upholding Illinois' assault weapon ban. The Seventh Circuit's reasoning? AR-15s are too militaristic and useful in military service. Therefore, they can be banned. This is absurd logic. The Supreme Court in Heller said arms in common use for lawful purposes are protected. The Seventh Circuit invented a new militaristic test out of thin air. The district court, bound by Seventh Circuit precedent, ruled for Cook County and upheld the ban. The plaintiffs appealed to the Seventh Circuit, but after the Supreme Court denied review in the Maryland Snoop case, the Seventh Circuit felt free to reject the Cook County appeal too. The Seventh Circuit treated AR-15s as civilian M16s, and therefore outside Second Amendment protection. So now the plaintiffs are at the Supreme Court asking, please resolve this. Do Americans have the right to own AR-15s or not? Kavanaugh's promise. Here's where Justice Kavanaugh's statement becomes critical. Last term, when the Supreme Court denied review in Snoop v. Brown, the Maryland rifle ban case, Justice Kavanaugh issued a statement. He wrote that while the court was denying review in that case, the time would come soon where they would need to take up a rifle ban and address this issue. He said this would happen in a term or two. The plaintiffs in Cook County are pointing to this statement and saying, Justice Kavanaugh, you promised. Here's the case. Take it. The question is, was Kavanaugh serious, or was it just empty words to calm gun rights advocates while continuing to avoid the issue? We're about to find out this Friday. The Duncan magazine ban. There's a second critical case also going to conference Friday. Duncan v. Bonta, the California magazine ban. This case challenges California's ban on magazines holding more than 10 rounds. The Supreme Court already GVR'd this case once, granted, vacated, remanded, telling the Ninth Circuit to reconsider in light of Bruin. But the Ninth Circuit came back and upheld the magazine ban again. They basically ignored Bruin. So Duncan is back at the Supreme Court saying, "You gave them clear instructions. They ignored you. Please step in." Both cases, rifle bans and magazine bans, are being considered together. This suggests the Supreme Court sees them as related issues. What relist means? Let me explain the significance of these cases being relisted for a third time. When the Supreme Court receives a petition, they hold a conference where justices discuss whether to grant review. Most petitions are simply denied at the first conference, but sometimes a case gets relisted, postponed to another conference. Why would they relist? Justices want more time to consider the case. They're waiting for related cases. There's internal disagreement about granting. One or more justices want to write a dissent explaining why search should have been granted. Here's the data on relists. According to Supreme Court analytics from 2016 to 2020, 31 to 43% of cases relisted once eventually get granted review. 66 to 75% of cases that are granted were relisted at least once. So a single relist is actually good news. It means higher chances of review. But multiple relists can be a warning sign. Often it means case will likely be denied, but one or more justices want to write a dissent explaining why search should have been granted. However, there are outliers. The Cargill bump stock case was relisted 12 to 14 times and still got granted. So multiple relists don't guarantee denial, but they raise concerns. The third relist, good or bad? This Friday marks the third conference for these cases. What does this mean? Positive signs. These cases survived two conferences where other Second Amendment cases were denied. NFA SBR cases, Rush, Robinson, went to the same conferences and were denied immediately. Machine gun ban case, Morgan, was denied after the first conference, but rifle and magazine bans survived. They keep getting relisted. This suggests at least some justices are interested. Negative concerns. Multiple relists often mean eventual denial with dissent. The Supreme Court has avoided rifle and magazine bans like the plague. They might not want to take these cases despite Kavanaugh's statement. A third relist increases the odds they're preparing to deny. My analysis: I think the Supreme Court is genuinely struggling with whether to take these cases. Some justices, probably Thomas, Alito, and Gorsuch, want to grant review. Others, probably Kagan, Sotomayor, and Jackson, want to deny. The swing votes, Kavanaugh, Barrett, and Roberts, are torn. They know they should take these cases, but they're worried about the political backlash and practical implications. What happens Friday? This Friday, January 9th, the Supreme Court holds conference. Here's what could happen. Option 1. Grant review. The Supreme Court grants cert in one or both cases. Oral arguments would be scheduled for spring 2026, decision by June 2026. This would be huge. We'd finally get a Supreme Court ruling on AR-15 and magazine bans. Option 2. Deny with dissent. The court denies review but issues dissenting opinions, probably from Thomas, Alito, and Gorsuch, explaining why they believe search should have been granted. This would be disappointing but would signal future willingness to take similar cases. Option 3. Relist again. The court relists these cases for a fourth time. This would be increasingly unusual and would suggest deep internal disagreement. Option 4. Outright denial. The court simply denies review with no explanation. This would be the worst outcome and would show Kavanaugh's promise was empty. We'll know the answer when the order list is published, probably Monday, January 13th.
Why this matters. Let me explain why these cases are so critical. First, the most popular rifle. The AR-15 is the most commonly owned rifle in America. If it's not protected, what is? Second, Kavanaugh's promise. Justice Kavanaugh said they'd address this in a term or two. If they don't take these cases, his promise was meaningless. Third, circuit confusion. Different circuits have different rules. Some say AR-15s are protected but can be banned. Others say they're not protected at all. The Supreme Court must provide clarity. Fourth, state bans. If the Supreme Court takes these cases and rules for gun rights, it could strike down AR-15 and magazine bans in California, New York, New Jersey, Illinois, Connecticut, Massachusetts, Maryland, and more. Tens of millions of Americans would regain their rights. Fifth, lower court defiance. Lower courts are ignoring Heller and Bruin. They're inventing new tests. The Supreme Court needs to enforce its own precedent. Sixth, future regulations. Whatever the Supreme Court says about AR-15s will affect all future gun regulations. The reasoning will apply to everything. This is about whether the Second Amendment is real or just suggestions that states can ignore. What gun owners should do. With conference this Friday, here's what you need to do. First, mark January 9th on your calendar. Conference happens Friday. Order list probably Monday, January 13th. Second, prepare for any outcome. Grant, deny, or relist again. All are possible. Third, support organizations like SAF fighting these cases. They need resources. Fourth, don't get discouraged if cases are denied. The fight continues in other cases and circuits. Fifth, if cases are granted, prepare to follow oral arguments and eventual decision in 2026. Sixth, spread awareness. Most gun owners don't even know these cases exist. All right, Patriots, this Friday, January 9th, could be a historic day for the Second Amendment, or it could be another disappointing denial. Let me summarize. AVIHAMTE versus Cook County and Duncan versus Bonta go to conference Friday. Third relist survived where other 2A cases were denied. 31 to 43% of relisted cases eventually get granted. Justice Kavanaugh promised to address rifle bans in a term or two. Could strike down AR-15 and magazine bans nationwide. Order list expected Monday, January 13th. Justice Kavanaugh, we're watching. Will you keep your promise? If you found this valuable, smash that like button. Share with every AR-15 owner. Subscribe for the order list coverage Monday. Comment, do you think the Supreme Court will finally take these cases, or will they deny them again? Until next time, stay armed, stay informed, and never stop demanding the Supreme Court protect constitutional rights. God bless America and the Second Amendment.